I believe certain things about trying a case, ladies and gentlemen, and because those items of my belief will inform everything else that I have to tell you in the course of the day, let me begin by enumerating them. First, I believe that trying a case is an art. Like every other art, it combines talent or inspiration with craft. The talent, the inspiration, the God-given divine spark, you have because you have it. And if you don't have it, there's nothing you can do to acquire it. And beyond that, I will not say one word more about it. Assuming you do have it, however, you are not yet an artist. God, or nature's God, made Rembrandt, but Rembrandt needed to learn how to hold the brush and in what manner mechanically to apply the paint to the canvas. That's the craft part of artistry, and it's the craft of trial advocacy which is our subject today. I believe that this craft of advocacy exists independently of the jurisdiction in which you're trying a case. It makes no difference whether it's federal, state, New York, Michigan, Mississippi, California, or any place in between. Nor does it make a difference what the nature of the case may be. Civil, criminal, divorce, antitrust, income tax evasion, the craft of advocacy remains constant. And finally, it makes no difference what side you're on. If it's a criminal case, you can be prosecutor, you can be defense counsel. If it's a civil case, on the plaintiff's side, on the defendant's side. The craft of advocacy is the same, no matter the position the lawyer espouses. I think of this craft of advocacy as existing in between the law of evidence on the one hand and the law of procedure on the other. A certain amount of overlap at the margins, to be sure, but the craft of advocacy is different from those other two long since recognized bodies of learning. And finally, I believe that one of the principal characteristics of this craft of advocacy, and something that distinguishes it from the other areas of the law that we've studied, is that the craft of advocacy, like those other areas, is full of the most fascinating problems, issues, and questions. But by contrast with those other areas, there is almost never one correct answer. So much depends upon the particular circumstances of the case, the feel of the courtroom at that very moment, your personality, the personality of the opposing lawyer, the personality of the judge. All of these variables come together and make it impossible to think of just one correct answer. I prefer to think in the craft of advocacy of thoughtful answers. Answers to these questions, problems, and issues which are arrived at by a process of thinking about them. And if you have thought about your problem and come up with an answer, that is your correct answer, in the sense that it's the answer you have an obligation to yourself, your client, and the profession to arrive at. But of course, your correct answer need not be my correct answer, nor must mine be yours, because we are different personalities, and every case will differ from every other case. To be avoided, then, are the thoughtless, the automatic, the unthinking responses in the courtroom. Now, we have a long time together, from now until 5 o'clock this afternoon. I should say that it's going to seem like a long time. As a matter of fact, by the latter part of the afternoon, it will begin to seem like eternity. But still, it is not. It is only 6 or 7 hours. And in 6 or 7 hours, we cannot begin to discuss every aspect of the craft of advocacy. I must perforce draw lines. I must simply eliminate vast areas that we will not discuss because of the lack of time, and let me mention one of those vast areas. Everything that I have to say, starting in just a moment or two, presupposes, ladies and gentlemen, a jury in the box. We will be discussing jury trials. Again, I repeat, it can be a jury trial in federal court, in state court, it can be civil, criminal, you can be plaintiff or prosecutor, you can be defense counsel, it makes no difference. But everything assumes a jury in the box. And the reason I draw the line that way is, first of all, we don't have time to discuss the other great kind of trial, a bench trial. But in addition, it seems to me that if you know how to try a case to a jury, why, of course, you know how to try a case to a judge. By contrast with a jury trial, a bench trial is taking candy from a baby. I will put it as baldly as I can. You can almost always fool a judge, but you can never fool a jury. And if you don't believe me, so be it. But let me tell you, that's one of the lessons I learned from my experience, such as it was in the trenches, trying cases. So much by way of forward, and now chapter 1. If we're going to presuppose a jury in the box, we'd better talk about getting the jury into the box. And so the first topic, naturally, is jury selection. Picking a jury, if you will. And in using those phrases, of course, I have simply used the customary language. All trial lawyers talk all the time of selecting a jury or picking a jury. But that is simply the inertia of language at work. Those phrases do not accurately describe the process, whatever the differences of detail in your court as opposed to the court across the street or down the river. If we had the language to invent anew, we would not speak of picking a jury. We would speak rather of unpicking or unselecting a jury. And it's more than a pedantry of language. In fact, it accurately describes the process by which you analyze what you will be doing when you pick the jury. The reason it would be well to avoid the idea of picking a jury is just this. As we all know, no lawyer ever picks a jury, in the sense that no lawyer plays any part in determining the identity of the people who are called into the jury box. It is chance that determines the hundreds of people who are summoned for jury duty that term of court. It is chance who determines the identity of the 6 or 12 who come out of the panel to sit in the box as the prospective jury in your case. You cannot control that. What you can do within certain limits and with differences of detail from one court to the next is to cause certain of those people to be excused, to be told to step down from the box. What you do then is unpick the jury. Chance deals out the cards. Within certain limits, the law allows you to take certain cards out of the deck. Now, I'm not going to reform the language standing before you. So, having given you that forewarning, from now on, I will use the customary term. We talk of picking a jury, but remember, always we ask ourselves, who ought to be excused from this jury? And in a nutshell, the way in which you go about planning your jury selection is, I suppose, the following, and I give it to you simply as a figure of speech. It's too vague to be helpful in the practical circumstances of a real trial. But this, I suppose, would be a way of thinking of it. The trial lawyer must have in his or her mind the profile of the ideal juror for that case. You measure the prospective jurors sitting in the jury box by that ideal profile. And it's self-defeating to ask yourself who comes closest to the ideal. That just won't work, if only because it is so inefficient. What you do is ask yourself who departs farthest from the ideal. And those are the ones you excuse. Those are the ones you cause to be told to step down from the jury box. And that's what I mean when I say that you unpick rather than pick the jury. Now, when you come to jury selection, I think we'd all acknowledge that what I like to call local practice or local custom is of considerable importance, more so than with respect to any of the other aspects of the trial. And by local practice or local custom, I mean that would include even rules of law, but I mean those matters which are difficult or impossible to look up in a law library. For example, if I had to pick a jury in a federal civil action and I wanted to know how many peremptory challenges I would be given, it's easy. Any law library in the land will give me the Federal Rules of Civil Procedure, and there the number will be set forth. But now the next question would be something like, how do I indicate that I wish to exercise a peremptory challenge? What words do I say? Do I sit or do I stand? Is there any ceremony that is expected of me? Well, as a matter of fact, in the federal courts where I tried my cases, there are certain words and ceremonies that will be expected of me. But you can't look them up in a book. They are matters of custom. You cannot select a jury without informing yourself of what I have described as local custom or practice. The single best way to acquire that local custom or practice, of course, is to go to court and watch a jury selected in a case other than your own. Go the week before or the day before. Sit in the back and observe. Preferably it should be a jury selection presided over by the judge who will preside over your jury selection. That way you get some idea not only of the customs in that courthouse, but even of the predilections and the desires of the judge himself or herself. And every judge, of course, has idiosyncrasies. Every judge wants you to do it in a certain way. And on the well-established principle of paying the $2, you do it the way the judge wants. There's no reason to fight with him about it. For example, back home in New York, I had a colleague, I put it in the past tense because he's now deceased. When I was on the bench, he was a judge too, and so he was a colleague. I had a colleague who had certain expectations, or certain, you might say, rules of his own. For example, if you are a male and you walked in to pick a jury before that judge and you happened to be wearing a bow tie, he ordered you to remove it. His rule was you could not wear a bow tie when selecting a jury. Don't ask me why. That was his rule. And on the principle of paying the $2, when he says, take it off, you take it off. And then you say, but Your Honor, I'm now naked before the jury. He says, no, you're not. And out of the top drawer of his desk, he pulls a tie. And he hands it to you, and he says, you may wear this today, bring your own tomorrow. And lest you think him uneven in his application of justice, I tell you that if you are a woman lawyer and you walk in to pick a jury wearing a hat, he says, take it off. In my courtroom, women may not wear hats when selecting a jury. And there is a well-known, very able criminal defense lawyer in New York who is both a woman and an habitual hat wearer. Not Bella Abzug, but somebody in that style of dress, who once appeared before him. And the judge said, take it off. And she said, no. And he said, take it off, I'm the judge. And she said, so what? And he said, go to jail. And she went to jail. 2 days she sat in jail with the hat on. The warden reported she wasn't going to take it off, so he said, okay, let her out. It's futile. And they went ahead and picked the jury with the woman wearing the hat. Shows you who will always win. Enough on local practice. Let's turn now to matters of law. Matters of law which are constant right across this land of ours. The only differences will be differences of picayune detail and of terminology. Granted, we understand that you are permitted within limits to remove certain cards from the deck. What are the methods of removing those cards? What is available to you by way of unpicking or excusing particular jurors? There are 4 such methods, and they are recognized everywhere. Let me pause to point out to you that we have here the first of 20 or 30 checklists that you will get from me in the course of the day. Understand the nature of a checklist. There is no need to reinvent the wheel every time you try a case. The work has been done for you. Take advantage of it. Each of these checklists is as near a complete listing as I can manage of the possibilities. Remember that you do nothing unthinkingly. You think about these possibilities and decide which of them or all of them are appropriate in your case and go ahead and do it. But at least the basic foundational work need not be done. It's been done for you. So here is the first of these checklists, and a rather simple one it is. The 4 methods of getting rid of a juror. First, the challenge to the array. I can't imagine a situation in which a prosecutor would make such a challenge, but defense counsel frequently will make it. As you know, the challenge to the array is a challenge not to any particular juror, but to the entire panel of people who have been summoned for jury duty that week or month or term of court. The nature of the challenge always rests upon some deficiency in the process by which the names have been selected. And the nature of the deficiency is always such as to produce an imbalance. That is to say, the process favors whites over blacks or blacks over whites, elderly over young or young over elderly, men over women or women over men, whatever it may be. So that, the argument will be, the jury is not a fair cross-section of the community. Such a challenge is obviously planned out well in advance. There will be leisure to go to the library to look at the cases in your jurisdiction. There is no need to use it, as it were, shooting from the hip. And so, having mentioned it, let's pass to the others, which you do need on the spur of the moment in court. The second of the 4 methods of getting rid of a juror bears a name that falls trippingly from the tongue of every trial lawyer. We use this expression over and over, but most of us, myself included, use it inaccurately when we do use it. This is the challenge for cause. And when lawyers talk shop, they frequently tell war stories about bizarre challenges for cause that came up. We usually really don't mean a challenge for cause. A challenge for cause, correctly understood, is a challenge to a particular prospective juror resting upon facts peculiar to that juror, and the existence of those facts requires the judge to grant the challenge. And the key word is requires. The judge has no discretion in the matter whatsoever. If these are the facts, the juror must be excused. Example, assume the lawyers are conducting the questioning of the jurors. Juror number 2, do you happen to know the defendant in this case? Well, yes, I do. How do you know him? He's my brother. Your Honor. Now, suppose the judge responds, well, he may be his brother, but he looks like an honest man to me. I think we'll leave him on the jury. Suppose the judge does that. Well, judges do all kinds of weird things, but if the judge does that, it is error, and in all probability, reversible error. That's a challenge for cause. If the juror is the brother of the defendant, the juror must be excused. The grounds that will support a challenge for cause are always set forth in the statute in your jurisdiction. But at a minimum, every statute says that consanguinity, blood relationship within a certain degree of closeness, is the basis of a challenge for cause. If you pick your juries in a large urban area, you very rarely run into a challenge for cause simply because the odds against the defendant's brother showing up in the jury box are so great. It's not impossible, but it's great. What most lawyers really mean when they use the term challenge for cause is a different kind of challenge that has a wonderful, elegant, old-fashioned common law name, and because I love elegance and old-fashioned things, I'm engaged in a small-scale campaign to try to get lawyers to use this phrase. It is a challenge to the favor. A challenge to the favor. And of course you know what it is. It is a challenge to a prospective juror resting upon facts peculiar to the juror's background, yes. But the existence of those facts by no means requires that the juror be excused. Instead, those facts will support the judge's exercise of his or her discretion. It is what we say when we talk shop, a judgment call. Either way is correct. The appellate court will not be interested. Example, juror number 2, do you happen to know the defendant? Yes. How do you know him? We were high school classmates. How long ago was that? About 12 years. Have you seen him since graduation? Once, at the 10th class reunion. Your Honor, may the juror be excused. What's the right answer? Either answer. The judge can say, well, he looks like an honest man, we'll leave him on the jury, or the judge can say it's probably better that he serve on some other jury. That's the nature of a challenge to the favor, and it's not terribly uncommon. Fourth and last and most important on this checklist of ways of excusing jurors is the so-called peremptory challenge. In some states it's called something else, but you all know what I mean. Some states it's called a strike. It is a method of excusing a prospective juror, and when we speak loosely we say it's a method of excusing a prospective juror for no reason. But of course we don't mean that. You should never do anything in a courtroom without a reason. It's not that you have no reason for excusing the prospective juror. Rather, your reason is yours personally. The settled rule has been, there are a couple of cases suggesting maybe the rule is changing, I'll mention them to you in a couple of minutes, but the settled rule has been that when a lawyer exercises a peremptory challenge, a peremptory strike, whatever the lawyer's reason, the lawyer need disclose that reason to no one, because no one, neither trial judge nor appellate judge, has the right to second-guess the lawyer, to be a Monday morning quarterback, to tell him that his reason was unacceptable. As I say, that's perhaps beginning to change, but we'll hold that for a little while. Peremptory challenges are available by law every time a lawyer picks a jury. The second most important thing to remember about the peremptory challenge, however, is that while you have it as a matter of law, you have it to a certain number, and the number is low. Now, whatever the number is will be set forth in the statute in your jurisdiction. There's no standard number, but it's always a fairly low number. That's the second most important thing to remember. The first most important thing to remember is that every trial lawyer must acquire the habit of thinking about the number of peremptory challenges not as an absolute number, but as a remainder. It's never how many do you have, but how many do you have left? And you see the peremptory challenge as a constant process rather than a number. For example, suppose that you are picking a jury. Suppose, simply to take an easy number, that the statute says you have 3 peremptory challenges. The novice, the beginner, the person who's not yet very skillful at this, will constantly say to himself, I have 3 peremptory challenges. The older hand at it will be saying, how many do I have left? Thus, you look at those jurors. And remember, you have in your head a profile of the ideal juror, and you use that profile to measure the actual jurors, and you excuse the ones who depart farthest from the profile. And you look at juror number 4, and you say to yourself, I hate him. That's a very good feeling to act on. You know why you hate him? You don't know him. You barely know his name. You've been in his presence for 20 minutes, but you know why you hate him? There's no doubt about it. You hate him because he hates you. That's what you are responding to. The brain is the seat of the personality. And you don't have to be a professor of physiology to know that the brain is a low-wattage broadcasting station. There is no doubt about that at all. We simply don't yet have the technology to tune in on it. Unless, you know, you put the thingies over here and you read the little needle that goes up and down, the electroencephalogram. But we respond to the radiations that are coming out of other broadcasting stations. The responses are very general, to be sure, but we are responding to them. You hate that guy because you are getting his broadcast to you. And his broadcast to you is, I hate you. So, you got 3 peremptories, use 1. Get rid of them. How many do you have left? 2. That's what you keep looking at. And now you look over at juror number 6. He makes your flesh crawl. Why does he make your flesh crawl? Because you make his flesh crawl. You want to get rid of him? You've got 2 peremptories. Go ahead and get rid of him. But when you do get rid of him, how many are left? 1. And remember, it's always the remainder that you look at. And now you look at juror number 5. He leaves you feeling uneasy. You don't hate him. He doesn't make your flesh crawl. But there's something not quite right about him. Can you get rid of him? Of course, you've got 1 peremptory, but then how many will you have left? 0! That's the point. You get rid of him, and what's there? An empty chair. Who will sit in that chair? You have no way of knowing, and you have no way of affecting the selection of the person who is called to sit in that chair. See? You unselect, you don't select. Who will be called to sit in that chair? Someone worse than, the same as, or better than the one you just got rid of. If it's worse than the one you just got rid of, you're in trouble because you have no peremptories left. If it's better, wonderful. But you don't know. So what do? What do you do? I don't know. Nobody knows. That's the fun of this business. Fun is not the right word. Right? That is the interest of this business. Right? It is why you're constantly on edge. You use that marvelous razor-sharp intellect that you've acquired, and you analyze problems down to a fine point, and when you get them down to the fine point, you say, I don't know. You close your eyes and you guess. That's why you get ulcers after a while. Well, now we've got the 4 ways of challenging getting rid of jurors. Now let's talk a little bit about the considerations that will come into play when you plan your strategy on jury selection. If we were a first-year class in law school, possibly a second-year class, I suppose the question I would put as professor would be, what kind of jury do you want? And after a certain amount of discussion, I would tell you the answer. And the answer, of course, in law school would be, you want a jury made up of people who are fair and impartial and unprejudiced and able to view the evidence coolly, rationally, and arrive at a just and lawful decision in the case. That is, I suppose, what I would be obliged to tell you in law school, but at least this professor would know damn well that it's not true. Not only is it not true, I believe that if a lawyer uses that standard in selecting a jury, that lawyer, first, is totally ignorant of the common law tradition of advocacy, second, is being faithless to his client, and third, probably ought to turn in his ticket and take up dentistry or some easier line of work. It is not the advocate's job to secure a fair and impartial jury. It is the advocate's job, as best he or she can, to secure a jury made up of the most bigoted, prejudiced, poison-minded, narrowly blinkered, people imaginable. You put it this way. You know who you want on that jury? You want 12 yous on the jury. You want to be on that jury because you will know how to decide that case. You will decide it in your favor. That's what you want on that jury. It's hard for laymen to realize, but there should be no secret about it, because we must go on to point out that when you pick a jury looking for those 12 prejudiced people prejudiced your way, you are not playing solitaire. There's another lawyer on the other side who's trying to do the same thing his way, and it's in the clash of the adversaries that the system seems to work. It's been working for 800 years, so there's something to be said for it. It's adversarial. You are an advocate, not an umpire. It's for the judge to be the umpire. You, within the limits set by, within the rules of the game, of course. You work as hard as you can on your side of it. Let the other lawyer work as hard as he can on his side of it, and somehow it works well. But if you don't work in the way the system expects you to do, if you start to be a statesman rather than an advocate, the system falls apart. It does. Well, we all know that. And to say that you want a jury made up of people who are absolutely biased in your favor doesn't help very much. So let me see if I can be more precise, more discreet than that. It has occurred to me, ladies and gentlemen, in the time in these last few years that I've had to think about it, that when you pick a jury, any case, any jurisdiction in the land, there are 3 purposes to be served, 3 goals to be accomplished. And what you're trying to do is accomplish all 3 goals. Obviously, you win some, you lose some. Sometimes you can't do it, but you try every time out. These 3 goals, ideally, will be accomplished in every jury selection, but remember, you don't accomplish them simultaneously. You accomplish them rather serially. At this moment, you're working on goal 1, at the next moment on goal 2, at the next moment on goal 3. And one of the ways of beginning to refine or develop your style as a trial lawyer is always to have clearly in mind what goal you seek to accomplish, because different means are adapted to achieving different goals. And one of the hallmarks of an effective jury style is cleanness, crispness, square corners, knowing what you want to do and selecting the means that will achieve that end. That is the importance of identifying in your mind, of my helping you by stating it here, as I'm about to say, these different goals and pointing out the different means adapted to achieving each of those goals. At any given moment in a jury selection, you should be able to say, were I to come along and question you, I am now working at goal number 2, and this is what I'm doing to accomplish it. Or I'm working at goal number 1, and this is what I'm doing to accomplish it. And as you'll see, the means are very different, depending upon the goal that you seek to accomplish. Now, what are these 3 goals? I discuss them in what seems to me the ascending order of their importance. Oh, the first is important, yes, but the other 2 are even more important. What is the first? Well, it's the one that pops into your mind at once. It's the one that most speakers on trial practice talk about almost exclusively. I'm going to spend some time on it, but it's only 1/3 of what is to be accomplished. And this is the goal of acquiring information about the prospective jurors, so that you know whether there's a challenge for cause, possibly, whether there's a challenge to the favor, somewhat more possibly, and most importantly, so that you are in a position to exercise your peremptory challenges rationally, for a reason. With respect to acquiring information about the prospective jurors, I know of 5 ways. So here's another checklist. 5 ways of acquiring information. You will recognize that not all 5 may be feasible in any given case. There are considerations of money and time. But the 5 are available in every jurisdiction, and there will be certain cases when you'll use all 5, and in every case you will use at least 2 or 3 of the 5. Let's run through them. First, do not neglect the possibility of advance investigation. And for someone who's coming to this work for the first time, the question will be, how can you investigate in advance? It's you don't know whom to investigate. You don't know who is going to be in the jury box. That is true. You do not know which 6 or 12 people will be selected to sit in the jury box as the prospective jury in your case. But remember, those 6 or 12 are selected from the panel or veneer, whatever you call it in your jurisdiction, of people who have been summoned for jury duty that month or term of court. So far as I know, that list of people who have been summoned is a public document. Anybody can get it for the asking upon payment of the cost of photostating it, roughly $2. Now, in an urban area, that's a long list. And that's where the expense comes in. You are investigating everybody on the list so that you will end up having investigated the 6 or 12 people drawn from the list to sit in the jury box. I prosecuted my criminal cases in the U.S. District Court for the Southern District of New York. I was an assistant U.S. attorney, and once we used advance investigation. I got the list of people who had been summoned that month, and in the Southern District of New York in those days, it's going on to 15, 16 years ago, the list was 500 names long. So you call in J. Edgar Hoover, and you say, Ed, go investigate. And if you're in private practice, obviously you can't call in J. Edgar Hoover, you call in Paul Drake. Paul, go investigate. And he goes and he investigates. But to investigate 500 names, you know, that's 500 garbage bags to go through and 500, you know, it takes a lot of time. It's a lot of money. Well, actually, I didn't call in J. Edgar Hoover, but, and we didn't go and look at garbage bags. What we did was to run the 500 names through the FBI card file. You know, it's like a library card catalog, and it just gives you summaries of entries in various investigative reports all around the world on people. Now, most of the entries were absolutely innocuous. You know, somebody was drafted into the Army, something of that kind. But in connection with one person, we got a piece of information that we could not otherwise have obtained. There was just no way to get it. And on the basis of that information, I exercised one peremptory challenge. The most expensive peremptory challenge I have ever exercised, because it took 4 agents 3 days to run the 500 names through the files. That's 12 man days, quite apart from access to the files. But remember, your local police department may have files. In private practice, remember that a bank, an insurance company, a credit agency may have files. There are commercial credit reports, which are available. It's expensive, to be sure, but it's not overwhelming. And bear in mind that there are now credit privacy statutes that you've got to worry about, but that's a subject for a different occasion. In any event, to some extent at least, in some cases, there will be the possibility of advanced investigation, and we move on to the second way of acquiring information about the jurors. And this is the assistance that is available from the, quote, social scientists, close quote. And I put it in quotes because that's the name they like to use. I don't think that they are scientists, but I could well be wrong. These are people who, as consultants for a fee, and occasionally for nothing if their heart is with you, will assist the lawyer in the trial of the case, but principally will assist the lawyer in the process of jury selection. These are the psychologists, the sociologists, even an occasional psychiatrist or two, who will help the jury on jury selection. Now, I must tell you that these people came on the scene after I left the trenches. I had completed my tour of duty, such as it was as a working trial lawyer, when these people showed up. So I have never had the experience of working with them. I have, however, read what there is to read about it, and I have a good many friends who are still active trial lawyers, and some of them have used the social scientists, and I've talked with them about their experience. So what I put before you, I believe to be true, but still it's based upon the experience of others. It's all vicarious. I have nothing of my own to report. With respect to jury selection, what the social scientist will do for you is, in a nutshell, the following. As the social scientist would say, he or she will use exquisitely sensitive sampling techniques to pick 20, 30, 40, or 50 people in the community to interview, frequently over the telephone. On the basis of the answers to the questions asked in the interview, the social scientist will construct a profile of the ideal juror in that case, having in mind the nature of the case, the identity of the litigants, where you are, when you are, what people in the community seem to be thinking, etc., etc. They submit that profile to the trial lawyer, who then uses it in the fashion with which we're all familiar. That's what the measuring stick, by which you determine which people in the jury box depart farthest from the ideal and hence ought to be excused. Now, this can be expensive. When last I was informed, it was running something like $30,000, $35,000, and that's a lot of money, of course. Those friends of mine who have used these social scientists report that the profile that you get, the report that the social scientist submits, is always quite sensible, by which the lawyer means that it's in accord with the lawyer's own intuition and common sense. To which I would say, well, if that's so, why do you need the social scientist? if you're told the same thing your own intuition tells you, why do you have to pay $35,000? And the answer frequently is the client wants to, because the client feels better. Now, an example, the only example I can give you, because it comes out of a real case, which I'll tell you about, and you've all read of it, but I didn't try it. A friend of mine tried it, but he has discussed it in public. Since he's discussed it in public, I assume his client says okay, and there are no confidentiality problems. Several years ago, you will recall, John Mitchell and Maurice Stans were tried in the federal court in New York. This was not a Watergate case. Watergate came later. It's the one in which Mitchell was convicted and has just finished serving his sentence. The one in New York was the trial of an indictment for attempting to fix an SEC investigation. And it was the one that resulted in an acquittal for all defendants. John Mitchell was represented by a dear friend of mine named Peter Fleming, who is now in private practice in New York, specializing in the defense of white-collar, complex criminal cases. Peter defended Mitchell, and Mitchell paid some $36,000 for a social science survey to assist in jury selection. They have the nature of the case. Fixing an SEC investigation, the client is John Mitchell, you're in New York City, the Southern District of New York, that's essentially Manhattan and the Bronx. After spending John Mitchell's money, the social scientist reported back to Peter, my friend, the lawyer, as follows. Peter, the ideal juror in this case, having in mind the client and the charge and where we are, the ideal juror is a white, male, Anglo-Saxon, registered Republican, Protestant, earning at least $100,000 a year. To which, of course, the only intelligent response is, what else is new? Well, of course, that's the ideal juror in this case. But while it's a frolic and a detour, let me tell you that if you don't know Manhattan and the Bronx, as I was born there, I know, you think of Manhattan as kind of the most glamorous and expensive place in the world. It's not. The glamorous and expensive people work there. They don't live there. And of course, it's the residents who supply the jurors. The Southern District of New York consists of Harlem and South Bronx for jury selection purposes. And so what the social scientist has described is in fact the smallest minority there is in the Southern District of New York. There are no more than 12 such people in the entire district. And do you know what? Every one of them ended up in that jury box. The odds were trillions to one. But Peter has said publicly that the instant the jurors' names were called, he knew he was going to win that case. It was the once-in-a-career situation where the jury consists of 12 defendants. There were 12 John Mitchells sitting there in the jury box. So obviously, there was going to be an acquittal, and of course there was. So much for social science. It is a rare case in which you can use the social scientist. As a prosecutor, I suppose it's just impossible. It is a somewhat less rare, but still uncommon case when you'd be able to engage in advanced investigation. The third, fourth, and fifth you have every time. So let's spend most of our moments on them. Third, what I call the information on the jury slip. Now, the jury slip is my own term. Let me tell you what I mean. Whatever you call it, you have it in every single jurisdiction. In the East, not just New York, but in all of the Middle Atlantic and New England states, it's literally a slip of paper. That's why I call it the jury slip. When the bailiff or the clerk puts his hand in the wheel and pulls out a name, and that name becomes juror number 1, number 2, and so forth, the very slip of paper that is pulled out of the wheel is what I have in mind. That slip of paper is automatically given to the lawyer. It contains minimal information. In New York, both state and federal, that information is name, address, occupation. No state gives you less than that. I have learned that a number of the Midwestern states have adopted a better practice, I think. When the jurors report in for jury duty, they are handed a rather elaborate questionnaire, much more than name, address, and occupation. Marital status, children's ages, education, all, the kind of thing a census taker would take if you're the fourth household. That questionnaire is the jury slip. Whether it be the short form you would get in New York or the more elaborate form you get in some of the other states, remember that you do get it. Use it. And use it in that way that every trial lawyer must acquire. That is to say, you've got to learn the art, the knack of putting two and two together. It's not only taking the information at face value, but correlating the information so that you get more information than appears on the face of the jury slip. Let me give you some examples of that. And you understand you can never be certain of these things, but it's probable that you're right, and after all, probabilities are all that you have to go on. Well, to begin with, I mean, obviously, you look at the prospective juror. That's going to give you race, it's going to give you age, approximate, but enough for your purposes, and it's going to give you gender or sex. So you've got that. Now let's look at the jury slip. And I'm going to use the Eastern version, the minimal form, because at a minimum, this is what you get everywhere in the country. You've got name, address, and occupation. Look at the things that you know. First, when I pick a jury, or when I did pick a jury, one of the most important things I wanted to know was ethnic background. Now, this is sometimes a little uncomfortable to discuss, but I will not be unduly immodest about it. In our own lives, we do not judge people on the basis of race, religion, or ethnic background. We have learned that that is a wholly immoral and self-defeating way to do it. You judge people as individuals. What is the worth of this human being? That's what's important. But when you're picking a jury, there's simply no time to explore the contours of a personality. You must take shortcuts, you've got to rely on hunches, and you must take into account stereotypes. The very reason the stereotype exists is that there is some truth to it, enough truth to make it worth considering. And while it touches the nerve, it's contrary to the way mother brought you up. You have an obligation to your client to use it for what it's worth. Obviously, it's not decisive. Ethnic background is not alone what you decide on, but it's a factor to be considered. I mean, really, do you need me to tell you that Italians are different from Irishmen, and that Germans are different from Jews? I'm not saying one is better than the other, but they are different. Different traditions, different ways of bringing up a child. And can you think of anything more important in forming a person's outlook on the world than the way in which he was brought up? And remember that for the prospective juror, the world he's going to have before him for the next 2 or 3 days is the world of that lawsuit. You're going to put the world before him, and you want to have some advanced notion of how he's going to respond to that world. So you'd like to know whether somebody came from Italy, or his parents did, or his grandparents, or somebody came from Ireland, etc. You know, it's an interesting thing. Assume a lawyer conducted voir dire. We'll come to that issue in a little while. Assume a lawyer conducted voir dire. To my knowledge, there is no case and there is no statute anywhere in the land that forbids you to ask the kinds of questions that I would want to ask. I've just told you that I want to know ethnic background. Is there any judge anywhere who would not permit me to ask, where did your parents come from? Where do you come from? Where do your grandparents come from? Absolutely not. Would I ask it? Of course not. That's something you've got to learn. And I'll suggest a way of getting at it. Forget about law. Law is unimportant here. You can ask anything you want as a matter of law. But most of the things you'd like to ask, you don't dare ask. And here's the rule of thumb that'll tell you what you can ask and what not. These jurors, with their conscious minds, are aware that they're participating in an elaborate artificial proceeding. But remember, it's brand new to them. They're not trained to it. They don't live with it the way we do. Jurors will respond to you the way they will respond to any other person they have just met. And they may not be aware of it, but this is what they're doing. They're equating the jury selection process with the last time they went to a cocktail party, a dinner party, or a backyard barbecue at which they met somebody for the first time. You're the somebody they're meeting. Ask yourself, suppose I were meeting this prospective juror at a backyard barbecue. Would it be appropriate, would it be graceful for me to ask him the question I want to ask? If it would, ask it. And if it wouldn't, don't ask it. The juror will be offended. And if you want to put it to the test the next time you go to a cocktail party, a dinner party, or a backyard barbecue, see how it works. You meet somebody for the first time. How do you do? I'm Irving Younger. Are you Jewish? You will discover that you're not invited back. Right? Look at the name. Look at the name on the jury slip. It may give you the ethnic background. I know it's perfectly obvious, but a lot of lawyers don't do it. I mean, obviously, Mr. O'Reilly is probably not Italian. And Mr. Weinberg is probably not Irish, and so on down the line. Probabilities, of course. You know, there are always exceptions, but you go on the probabilities. I'll grant you that New York is a polyglot place beyond any place else, and I'll also grant you that everywhere, as the generations move along, the ethnic identity of the name is getting ironed out. Ultimately, everybody's going to be named Smith. I'll grant you that. So there's at least one chance out of two that when you look at the name to get the ethnic background, it doesn't tell you, because it says Smith or Jones or something. Well, Jones is Welsh, but Smith isn't going to tell you anything. All right? So now look at the next item of information. I speak for myself. I dare say I speak for all of you. In addition to ethnic background, you know what else is as important? Economic class. Can you think of anything more important in affecting somebody's outlook on the world? There are things as important, but nothing more important than that. Is there any case anywhere that says you can't ask a juror how much money he made last year? No. Ask it if you want. But you don't dare ask it at a cocktail party, so you don't dare ask it in court. There's no need to ask it. Look at the address, and you will know the economic class. Within a couple of $1,000s, you'll know how much money he makes a year. Because if you're going to be a trial lawyer, you must not only acquire the knack of putting two and two together, you've got to become something of an amateur mailman. You must know the neighborhoods in your city, the way the mailman knows them. You've got to know what's a high-rent apartment district. You've got to know what's an area where there are private homes. Do the homes sell for $25,000 or $250,000? If you know that, you know what the economic class is. Give you an example. I've got to use New York City because it's the only place I know in this kind of detail, but everybody more or less knows Manhattan simply as a tourist. There's a juror sitting in the box. You look at him, you know that he's white, you know that he's about 40 years old, you know that he's male. Now you look at the name, John Smith, doesn't tell you anything. Now you look at the address, 10 East 78th Street. And you should know, I certainly know, that that is a neighborhood of apartment buildings. It is the highest rent, high rent district in the world. That's 20 feet off Fifth Avenue, right across from the Metropolitan Museum of Art. A one-room efficiency apartment goes for $200,000 a year. If you want a separate kitchen, it's $300,000 a year. So now you know that that guy makes a great deal of money. Don't stop there. You've got to keep putting two and two together. Look at the occupation. Put it together with the economic class, which you now know. In New York, that very guy, the guy I have described, will always list as his occupation self-employed. Very good. Now you know what he does for a living. He pushes heroin. And if he doesn't push heroin, so he pushes stocks and bonds. So what? So for you, these purposes, it's all the same. He pushes something for a living. And standing alone, that's not good, and it's not bad. It is simply one of the factors to be taken into account in deciding whether this guy ought to be on your jury. All right, so I dare say the point is made for information on the jury slip. Now the fourth. And for the fourth, I really get excited, because let me tell you, this fourth is my favorite. And here is why. For yours truly, this particular personality, I found that this fourth way was the most productive of all five. I got more information this way than any of the other ways. I'd almost say than the other ways put together. Second, most lawyers don't use this fourth way at all, so that if you do use it, you're automatically ahead. And last, and really best of all, this fourth way, unlike the others, you can start to practice at the coffee break in 40 minutes. You don't have to wait for the next time you pick a jury. And you know what it is? It is simply observation. Look at the jurors and see what is there to be seen. I need not tell you that every human being is a walking advertisement for the inner man or woman, so long as you know how to read the signs. Read them. They're telling you who they are. I mean really who they are, the shape of the personality. Not, obviously you don't know if he's married, if he has 2 kids or 3 kids. Who cares about that? When you pick a jury, you're not worried about that kind of stuff. That is for the census taker. What you want to have a feel for is the shape of the soul within the body. And that's the kind of thing they'll tell you, if only you know how to read the signs. What I am talking about, ladies and gentlemen, is the Sherlock Holmes ability. Remember that Dr. John Watson's retina was no worse than that of Sherlock Holmes. The very same stimuli appeared on Watson's retina as appeared on Holmes's. What Holmes had was the ability to see it, to react to it, to observe what everybody else overlooked. And what I am urging you to do is to become not only a mailman, but also a little bit of a Sherlock Holmes. And if it's been a long time since you read any Holmes, and you don't quite remember enough to know what I'm driving at, I'm going to give you a citation right now. When you go home tonight, and if it's not at home, when next weekend you visit your parents, go up to the attic where you will find the shelf of the books of your adolescence. Take down Doyle, the Holmes stories. Open to just one story. Its title is The Adventure of the Greek Interpreter. It's about 10, 11 pages long. Marvelous story. But if you don't have time to read all 10 or 11 pages, read just the first 3. To remind you, Holmes is stuck. So he visits his older brother, Mycroft. They stand at the window of the Diogenes Club in London. And just to pass the time of day, they look at the pedestrians on the street. Now, they're looking at them through the plate glass window. They can't hear what the pedestrians are saying. But being the Holmes brothers, what they do is vie with each other to see who can figure out most things about those pedestrians simply on the basis of what you see through the window. And it's marvelously clever and amusing, and it will inspire you to do the kind of thing that I think you have to do. Remember, the jurors walk in, and it's as if they are covered with signs saying, I am such and such kind of person. All you have to do is read them. Let me take just 3 fast examples. Clothes. Almost nobody dresses at random. Most of us are not fashion plates, but all of us spend at least 30 seconds in the morning deciding what we're going to wear. That decision bespeaks the inner man or woman. What it tells the careful observer is how you see yourself, because you dress in accordance with the mental picture of yourself that you carry in your mind. So you've got to just look at people. I mean, no great revelations. Just develop the habit of looking at them and learn a little bit about clothes. You're going to be a trial lawyer. Look at the developing list of occupations you must acquire. You're going to be a mailman. You're going to be Sherlock Holmes. And you're going to be something of a haberdasher or a woman's fashion expert. No kidding. A trial lawyer, at least once a year, should leaf through Vogue or Harper's Bazaar. Should take a look at the Sunday New York Times annual supplement on men's fashions. Every once in a while, just take a walk through a good men's clothing store in town or a good woman's clothing store in town. Get an idea of what is in fashion, how much things cost, what people who are conscious of themselves as clothes wearers will be wearing. Next, I assume that in your neck of the woods, as in my old neck of the woods, when jurors are waiting to be called down to the courtroom to participate in the selection process, they are told in advance, there is no television to watch, that no card playing is allowed. What you do in the central jury room is either stare at the wall, or talk to your neighbor, or read. Most people choose to read. They are told to bring what you want to read with you. There's no library here. And when you are called down to the courtroom, they are told, at least in New York, take it with you, because if you leave it behind, it will be stolen. So out of every 30 jurors, 25 walk in holding what they have been reading. Is there anything better as an insight into the nature of the man or woman? They've selected the thing they want to read. They've brought it with them from home. So you know what else you have to be? A little bit of a librarian to know the difference between things. For example, this guy is walking in his newspaper, the Wall Street Journal. The next guy, newspaper, the National Enquirer. Is there a difference between those two papers? Well, of course. Are those two very different people? Yes, sir. You will be surprised, at least I was surprised, to discover how many people read books. Not newspapers or magazines, but books. So you've got to know what people are reading and something about what the books are, how the books work, what the subject matter is. Here's a guy who walks in carrying an Agatha Christie mystery story. Well, why does he read Agatha Christie mystery stories? Because he enjoys it, obviously. And what does he enjoy? He enjoys the trick. The book is 200 pages long. For 199 pages, everything seems one way. You turn over to the last and 200th page, and suddenly nothing was that way at all. It was all something else. If I'm picking a jury for the defendant in a criminal case, I want that guy. Because when I'm defending a criminal case, that's my argument. It seems that way, but it's not that way at all. On the other hand, the next juror is carrying high on the bestseller list, A Distant Mirror, Barbara Tuchman's Popular History of the 14th Century. Now, he's not a professional historian, So he's not reading it for occupational reasons. He's reading it because he enjoys it. What does he enjoy? He enjoys the spectacle of an author meticulously working with thousands of discrete bits of evidence and putting it together to form a coherent picture, a mosaic of life 5 centuries ago. I'm picking a jury for the prosecution in a criminal case. I want that guy, because that's what I'm going to be doing. I take the little bits of evidence, of information, put it together, and try to show him how it makes a coherent, complete picture. I said I'd give 3 examples. I guess my third will be jewelry. Do you realize what you can learn from jewelry? And don't make the mistake of thinking that only women wear jewelry. All men wear jewelry. Most of you can't see me well enough to know, but suppose I were the prospective juror. You've been looking at me for an hour or so. Am I wearing jewelry? You should long since have noticed it. Sherlock Holmes would know. Well, of course I am. Not rings, not bracelets, but the watch. Everybody wears a watch. And you have to be a little bit of a watch seller, because I have discovered that especially for men, the watch is an extraordinarily detailed insight into the inner person. You're picking a jury, you look at a guy. He's 28, 29 years old, white, middle class, everything about him is middle class, occupation, he's a clerk in a bank. So what does he do all day? He adds up numbers, minute after hour, after day, after week, after month. He adds up numbers. That's his job. And you say to yourself, why doesn't he go berserk? If I had to do that in 20 minutes, I'd be off my rocker. He does it week after week after week. Why doesn't he flip? Look at his watch, and you'll have the answer. That guy, more often than not, is wearing the kind of watch that was designed for astronauts to wear when they walked the surface of Mars. Some of you may be wearing such a watch. You know, it has buttons. You press one button, the radar screen lights up. You press another button, the poison gas comes out. Now you know why that guy can sit there week after week adding up numbers. He's not adding up numbers. He's walking the surface of Mars. That's what he's doing. He is leading a rich fantasy life. And if I'm choosing a jury for the defendant in a criminal case, I want him. Because I want jurors who lead rich fantasy lives. On the other hand, suppose that very guy is wearing this kind of watch, the kind of watch I'm wearing. That's a $6 Timex with no added features at all. Fantasy life? None whatsoever. You know why that guy adds up numbers? Because he likes it. That's why. So long as they balance at the bottom of the page. And if I'm the prosecutor picking the jury in that case, he's for me. Because my pitch as the prosecutor always is it balances at the bottom of the page, and that's what makes him feel good. Enough on that. And when I say observation, or looking and seeing what is there to be seen, I mean the special kind of observation that is most famously represented in our culture by Sherlock Holmes, who, remember, had physical vision no more acute than that of Dr. Watson. But he actually saw what was projected on his retinal screen and figured things out based upon what he saw. Watson just didn't remark upon it at all. It just went right by him. Remember, Holmes at one point says to Watson, Watson, the difference between us is that I see what is there to be seen, and you do not. Every human being is a walking advertisement of the inner man or woman. All you've got to do is read the signs. And you may be picking that jury in a federal court where the judge will not allow you to ask one question of the jurors. So what? You realize we're now fourth. We've come to the fourth item on this 5-item list of ways of acquiring information, and we haven't yet mentioned asking questions of the jurors. We will. That'll be the last one. But you're in a federal court, let's assume. The judge won't let you voir dire, ask questions of the jurors. But you're in the room with the jurors. When they come walking in, you see them. Well, make sure that you pick up the signs. A couple of examples, just two, and then we'll go on to something else. Otherwise, I'll spend too much time on this. I assume that in your city, as in my city, when the jurors spend a lot of time waiting, and when they do wait, they wait in a great big room called a central jury room or a central jury part. They spend most of the day there. And in New York, as I assume even in this much more, what shall I say, much more favored city, the central jury room looks like a Greyhound bus station in a somewhat depressed Midwestern industrial town in reduced circumstances, right? So they sit there on the bench, and when they got the jury summons, there was a little mimeograph slip, and it said, you're going to spend a lot of time waiting. There is no television set. We do not allow card games or checkers or chess games. If you want to do something other than stare at the wall, you can read, but we don't have a library here, so bring your reading matter. That's what they call it. Bring your reading matter with you. Now, when the name is picked out of the wheel and they call him down to your courtroom from the central jury part, do you know what the clerk yells out? He yells out something like this. If you have brought reading matter with you, take it to the courtroom. Do not leave it behind, because if you leave it behind, it will be stolen. So, everybody picks up his newspaper, magazine, or book and comes walking into the courtroom holding his reading matter in his hand. For God's sakes, see it. And remember that it tells you something about the personality of the reader. I've said if you're going to try cases, you've got to be something of a postmaster. You've also got to be something of a librarian. You don't have to have read every book that people may be reading, but you must have some idea of the genre, the form, because after all, he reads it because it pleases him, and that gives you an insight into the personality. Right? Examples. Look at juror number one. He's carrying the Wall Street Journal. Tells you something about him, doesn't it? Look at juror number two. He's carrying the National Enquirer, and there is a difference between the two. At least know the nature of that difference. Look at number three. He's carrying not a newspaper, but a book. What book? An Agatha Christie mystery of some kind. You need not have read that particular mystery, but you must be enough of a librarian to know what those mysteries are like. And most of you do know. It's written to a formula. And the formula involves a novel about 200 pages long. The first 199 pages make it seem all that way. And then you turn over to the 200th and last page. And my God, it wasn't that way at all. It was this way. And that's what pleases him. And if I'm picking a jury for the defendant in a criminal case, I begin to want him. Because when I defend a criminal case, that's almost always my argument. I know it seems that way, but it's not that way at all. Right? But now, wait a while. Look at juror number four. What is he carrying? Many of you have read it. He's carrying the paperback, which came out about 6 months ago, of Barbara Tuchman's A Distant Mirror. Remember, you know Barbara Tuchman. She's our leading non-academic historian. And A Distant Mirror was on the bestseller list for almost a year in hardback. It's now out in paperback. It is a 600-page account of life in a particular part of what we today call France in the 14th century. Now, why is this guy reading that book? He's not a professional historian. He's reading it because he gets a kick out of it, that's all. But what does he get a kick out of? Well, I suppose it's participating with the author in taking thousands of bits of information and piecing them together to form a mosaic, a coherent picture of life in that distant place and time. And if I'm the prosecutor or the plaintiff in a civil case, I begin to like him, because if you have the burden of proof, what do? You take bits of information and you're trying to persuade the jury that you've assembled those bits of information to form a coherent picture of something that happened in the past. And here's a guy who's kind of attuned to that sort of thing. Right? So much on reading. That's my first example. I said I would give myself two examples. Jewelry. You're aware that just about everybody wears jewelry, men and women alike. And you've just got to see it. For example, I have been standing before you for an hour and 10 minutes. What jewelry am I wearing? And the trial lawyers in the room should long since have picked it up, not instinctively really, but habitually, at the coffee break in 20 minutes. Start doing that. I find, and every trial lawyer of experience I know finds that as you walk down the street, your eyes sweep
the pedestrians, just picking up information. You sharpen your skills that way and letting it run through your mind. What can you figure out about them just from what you see them? Well, I've been standing before you, and you've seen both my hands for an hour and 10 minutes, and what jewelry am I wearing? Well, let's begin with wedding rings. For example, a woman who wears a wedding ring is married, and a woman who does not wear a wedding ring is not. We all know that simply as part of our culture, a man who is not wearing a wedding ring may or may not be married. A man who is wearing a wedding ring is. Am I wearing a wedding ring? Very good. The answer is no. Am I wearing a mafia diamond pinky ring? No, because I'm not the type. And in any event, you saw that I wasn't wearing it. Well, am I wearing any other kind of ring? No. Well, that's not the end of jewelry. How about a bracelet of some kind? A charm bracelet? No, come on. One of those identification bracelets? No, not my style either. In fact, I'm not wearing that, but I am wearing jewelry. I'm wearing the kind of jewelry that at a minimum every man and almost every woman wears, which is why I said almost everybody wears jewelry. The watch. And in my experience, especially for men, the watch offers an extraordinarily vivid insight into the personality of the wearer. Now, let me give it concrete form. You're picking a jury. Let's say you're picking a jury, and there's juror number 3, and he's about 32, 33 years old, and his name is Smith, and he's white, and he lives in a middle-class neighborhood. So far, he just seems to be John Q. Average, and his occupation is teller in a bank, clerk in the back room of a brokerage house, something of that sort, the kind of person you run into by the hundreds picking juries in every big city. Now, you say to yourself, what does this fellow do for a living? What he does for a living, when you boil it all down, is add up numbers. See, he adds up debit and credit entries, hour after day after week after month. He's adding up those damned entries. Why doesn't he go berserk? That's the question I ask myself, because I know that if I had to do that job, I would last exactly 20 minutes and I'd be off the wall. How can he manage to do it? Day after week after month after year. Look at his watch, and his watch will usually tell you how he manages to do it, at least half the time. Back in my home city, that guy who sits there day after day adding up numbers in the back room of a brokerage house is wearing the kind of watch some of you are wearing. It's the kind of watch that was designed for astronauts to wear when they walk the surface of Mars. You know the kind. You press one button and the radar screen lights up. You press another button, the poison gas comes out, and so forth. But now, do you see what that tells you about that guy? It's the personality that you're trying to understand. That guy can sit there adding up numbers week after week after week because in his mind, he's not adding up numbers. In his mind, he's an astronaut walking the surface of Mars. Which means he leads a rich fantasy life. Which means that if I'm picking the jury for the defendant in a criminal case, oh, do I want him? Because I need jurors in criminal cases who lead rich fantasy lives, yeah? But now, wait a while. Suppose that very same guy is not wearing that kind of watch. You really can't see it very well, so I'll tell you. He's wearing the kind of watch I am wearing. That is an $8 Timex with no added features at all, indicating that its wearer leads no fantasy life whatsoever. Hey, what does that tell you about the juror? It tells you that he sits there adding up numbers day after week after month after year. You know why? Because he likes it. That's why he likes it, so long as what? So long as it balances at the bottom of the page. You know that kind of guy. It must balance. If it doesn't balance, that's when he flies off the track. He can't cope with the psychological distress represented by the fraying at the margins of reality, the sloppiness of the real world. It's got to be as neat as it can only be on the ledger page or in a computer printout, which means if I'm prosecuting, I grapple him to my soul with hoops of steel. There is a guy who is psychologically incapable of acknowledging the fact that in life as it is, you may have a doubt when all is said and done, maybe even a reasonable doubt, that it is sloppy, that you can't pack it up in a nice, neat package. All that from looking at the watch. Now, if I haven't succeeded in conveying it to you, let me give you a citation. You will get no more than 5 citations from me in the course of the day. Here's the first, and every one of them is very important. I want you to read something to illustrate what you can do by careful and astute observation. It's not a case. Most of what trial lawyers need to know is not in the law library. When you visit your parents some weekend soon, please visit them soon. Go up to the attic where your mother keeps the books of your adolescence. And there, assuming she keeps them in alphabetical order, under D for Doyle will be your one-volume Sherlock Holmes. Absolutely everybody had it from roughly the age of 10 to roughly the age of 16. Take it out and open it to one story and read that one story. It is called The Adventure of the Greek Interpreter. It's about 20 pages long. And if you're pressed for time and you can't afford whatever it takes to read 20 pages, then read just the first 4 or 5 pages of that story. The Greek interpreter is the client. He comes to Sherlock and he's got a problem. And Sherlock can't get a handle on the problem. He doesn't see how to work into it. So he goes to talk to his smarter older brother, Mycroft. And this story is the first appearance in the sacred canon of Mycroft Holmes, Sherlock's older brother. They meet at the Diogenes Club, a club in downtown London. And before they get down to business discussing the client's problem, they stand at the window of the reading room, Sherlock Holmes and Mycroft Holmes, looking through the plate glass window at the pedestrians on the street. Now, they can't hear what the pedestrians are saying because it's through the glass window, but they can see them. And being the Holmes brothers, they vie with each other at figuring out most things about those pedestrians based solely upon what you can see, their costume and their habits of walking and so forth. And it's done with enormous cleverness and panache and wit. It's funny, it's amusing, and it's inspiring. Because something of what Sherlock and Mycroft Holmes were able to do merely by observing those pedestrians is what you must be able to do as you sit there observing those prospective jurors. Which brings us to the fifth and last method of acquiring information. By and large, it is available only in a state court. There are some exceptions, to be sure, but by and large, that is so. And it's lawyer questioning of the jurors. We understand that this is a controversial issue among trial lawyers. By and large, lawyers like the chance to question jurors, and sort of the party line among judges is that it wastes a lot of time, let the judges do it, and that's essentially the way it's done in the federal court. Given my preference, I tell you, I would vote for a lawyer-conducted voir dire. It's much more flexible, there's more you can do with it, and properly used, it does not take much more time than a judge-conducted voir dire. On the other hand, most lawyers that I've seen question the jurors, and in the New York State system, that's the way you do it, so I've seen an awful lot of lawyers do it. Most of the lawyers do it ineffectively. It's just without purpose. So it's really a waste of time. And if that's the way it's going to be done, it doesn't much matter how it's done, whether by the lawyer or the judge, because either way it accomplishes nothing. But if a lawyer does it properly, I think you can accomplish a lot with it, and without taking a hell of a lot of time. Without turning it into a federal case, let me just get right to the heart of what I think you can do with the voir dire when you conduct it, which most lawyers do not do. Most lawyers use the voir dire to acquire bits of information, the sort of thing a computer programmer would call a bit, what you could feed into the computer's memory. The sort of thing that, well, it would go like, and this is not meant to be realistic, but to give you the hang of it. It's, sir, are you married? Yes. How, do you have children? Yes. How many? Three. How old is the eldest? And so on. Bits of information. I speak for myself, and I ask you to consider whether it wouldn't be true for you too. Yes, I'd rather have that information than not have it, but in the long run, it's not terribly important. I have no way other than a pompous way of putting it, so let me just put it pompously. What I am trying to find out when I pick a jury is what I can only call the contour of the personality. What kind of soul inhabits this body? Because that's going to give me a sense of how that personality or soul will respond to the world, the artificial world that I'm going to try to unfold in this courtroom. And knowing that he's married or has 4 kids or whatever it may be does not tell me anything worth knowing about the personality. But you know, in our own lives, private lives, we've all had the experience of, in a very short time, getting a sense of the personality of someone we've met for the first time. We have all learned to do it by the time we're 11 or 12 years old. And if you want to observe yourself doing it, the next time you go to a party of any kind where you meet people for the first time, reserve a little psychic wherewithal to watch yourself. Be conscious of what you do. Because unless you make yourself be conscious of it, you won't be conscious of it. It's so acculturated by now that you do it instinctively. We meet people and we talk to them, understanding that our purpose is getting a sense of the personality in accordance with the following ground rule, which is in our culture. It's unique to this culture. He talks for about 30 seconds on any subject at all, and you listen. And after about 30 seconds, it's your turn to talk, and he listens, and usually that's enough. And if it's not enough, one more go-around. A total of 2 minutes of conversation, about equally divided, on any topic. And you know what? You may not know whether he's married or how many kids he has, but you know whether you'd like to get to know him better, whether it's someone who may become a friend, whether it's a goodbye and good luck, but we're not going to see each other. You get a sense of who that is. Seems to me you do that in court, where it's a lawyer-conducted voir dire. Try asking open-ended questions. Don't ask questions that can be answered monosyllabically, yes, no, for, something like that. Ask questions that get the juror talking for as long as possible about anything. The subject doesn't matter. But you listen to that 30 seconds or 1 minute of extended speech from the juror, and it's amazing. At the end of the minute or so, you will know everything you need to know about that juror, in the sense that you can now decide whether you want him on the jury or not, even though you may not know how many kids he has. If you are going to ask open-ended questions, though, remember that there's a certain craft or technique to it. You can't just say to jurors, talk, because they're not accustomed to being in the limelight. They're under pressure. They are not professionals at articulation. We lawyers are, and most of us enjoy the limelight. And even if you don't enjoy it, at least you're more or less used to it. So you've got to be a little, what shall I say, clever or cunning in getting the juror to talk. When I was first selecting juries, I was 25 or 26 years old. I didn't know what I think I know now, and if I had known it, I wouldn't have known how to do it. When I was 25 or 26, with that advice reverberating in my mind, get him to talk, I probably would have said to juror number 2, "Sir, I see from the jury slip that you're a garbage collector." "That's right, kid," says he. Because he's getting ready to be insulted. You see, he's been the object of scorn all his life because he's a garbage collector, and he's 45 and I'm 25, and I had the luck to go to school for all those years and he didn't, so he's getting ready, right? So I say something like, because I got to get him to talk, right? "Well, Mr. Garbage Collector, would you please explain to everybody here in the room your views on capital punishment? Because I think that's a very good topic. I can speak for a day on capital punishment, so why can't he?" "Well, because I'm just dumb asking that question." He's got views on capital punishment. His views are worth exactly as much as mine. Nobody has any hotline to God on that one. It's just one man, one vote. But he can't talk about that. He's not skilled at putting such difficult thoughts into words. And what he will as much as say, you know that, he will cross his arms and look away, which is body language. That's all I'm going to say about it today, because everybody knows all about body language. And he says to himself, "You're humiliating me, kid. You're humiliating me because I'm a garbage collector, and you think I don't know about capital punishment. All right, kid, you can humiliate me, but I will get even." And you, even though you're 25 years old, you know that he's saying that. And he will get even in the jury room, which is why you've just used up one peremptory challenge. You've got to get rid of him. Now, I'm no longer 25, alas, so I really can't do it. But if I were 25, I think I would know enough now to play it something like this. "Juror number 2, I see from the jury slip that you're a garbage collector." "That's right, kid." He's getting ready. But now, isn't that interesting, sir? I remember reading in the Sunday paper a few weeks ago that garbage collecting is the most dangerous kind of municipal work there is, that more garbage collectors are injured on the job than policemen and firemen put together. Is that right, sir? "That's right, kid." See? You've turned him right around, right? Why is that, sir? What's the nature of the danger? How do you protect against it? Get them talking. And there's my advice. Almost always, you can get them talking about the details of their job. And you know, the more detailed their account is, the more interesting it is for everybody in the room. It's one of the secrets of Balzac's novels. The details of occupations are fascinating to everybody else. So, you get him talking about garbage collecting, and you listen carefully, and you know what you may decide after 30 seconds? He's a garbage collector with a 3rd grade education, but he's the smartest guy in this room. And he's got the most forceful personality. And he will probably lead that jury if he's on the jury. And that's important to know. Standing alone, it doesn't say one thing or the other, but it's an important factor to take into account along with everything else. And you get it by listening to him talk. Let me wind that up, not with a war story, but with an anecdote that I think really is important. Some of you may have seen it because it was in the newspapers. Remember last summer, the case of MCI against AT&T was tried before Judge Grady in the federal court in Chicago. That's the private antitrust action that produced the verdict of $1.8 billion, the largest verdict in an antitrust case, maybe in any kind of case, ever. That was tried to a jury. Now, one of the arguments on appeal will be that it should not have been tried to a jury. It's too complicated. And I know one of the lawyers and indirectly know the other. Before the verdict came in, before there was a loser and a winner, both lawyers said that was the best jury selection they'd ever been through, and they had absolute confidence that that jury would understand the case. Now, it was a federal court, so the judge questioned the jurors. Let me tell you what Judge Grady did. A certain amount of basic biographical information was on the jury slips given to the lawyers. Beyond that, the judge asked each juror to stand up, and then the juror asked preliminary questions to get the juror talking about anything. The subject varied with the juror. For one juror, it ended up with, tell us about your military service in the Second World War. For another juror, a motherly woman, how many children you have? They're doing well. Oh, yeah, they're doing well. You're proud of your children? Yeah, tell us about your children. So she starts talking about the children, and so on down the line. Each prospective juror talked for as long as he wanted, but not less than 2 minutes, about anything at all. And at the end of the 2 or 3 hours it took to do that, both lawyers said they knew everything they ever could want to know about those jurors. Maybe you can't put it into words, but you know it. And they had every confidence in that jury until, of course, the verdict came in, and the loser no longer has confidence in them. But that's the way the game is played. All right? Enough for my 5 ways of seeking to achieve the first purpose, which, remember, is finding out about the jurors. We've got 5 minutes before the coffee break, and in those 5 minutes, I think we can complete our discussion of the second purpose and the ways of achieving it. It's, in my mind, even more important than the first way. But there are only 2 methods of achieving it, and so we can discuss it briefly, but remember, the time that we spend on it is not to be taken as an index of its importance. This second method is acquiring, the second method is communicating information to the jurors. Bits of information, giving the information to the jurors. Now, that's awfully important, as you know. Why? As a footnote. Let me say why, though I know it's unnecessary. Every trial, from the simplest to the most complex, from a 2-hour hit-in-the-rear fender-bender case for $75 in property damage to MCI against AT&T last summer in Chicago to a $1.8 billion antitrust verdict, every trial is, from the juror's viewpoint, an enormously complicated mass of information to be absorbed. The jury has to be taught. And a way of thinking of your job as a lawyer is that you are the teacher and they are your student. And to the extent that you are successful in teaching them what you want them to know, you're on your way to winning that case. You begin to teach them at the earliest possible moment. Now, in a state-style jury selection, that earliest possible moment is the jury selection, the voir dire. And so one of the things that you will think about is, what do I want them to know right at the beginning? In a federal-style jury selection, where you can't talk to the jurors, that same question is important, but it's in the context of the opening statement, not the jury selection, because the opening statement is when you first get to talk to them. Assume it's a state-style voir dire. How can you communicate facts to the jury? 2 ways. First way, as a matter of unwritten law, you're not going to find this in any code or set of rules. Every judge in the land will permit you, when you first get up, to make a brief preliminary statement. Now, this is not the opening statement. That's going to come tomorrow morning. This is a preliminary statement before you actually ask the questions. My advice is, first, remember that you will be given the chance to make it, and second, prepare it. Think through what you want to tell them right at the start. So long as you do remember to prepare it, you will do something intelligent. If you don't remember to prepare it, this is what's going to happen. The judge says, do you want to make a brief preliminary statement? And you realize you're not prepared with one, so you say, no, Your Honor. You've given up a chance to teach the jury. Or the judge says, do you want to make a brief preliminary statement? And you say, my God, I didn't prepare it, but I'll wing it. So you extemporize a preliminary statement, and invariably, it doesn't do anything for you. At best, it doesn't hurt. At worst, it damages you. So remember to think about what you first want those jurors to hear from you and tell it to them in that preliminary statement. Second, past the preliminary statement, in a lawyer-conducted voir dire, remember, you question the jurors. I remind you, you all know it, that it's the nature of the English language that any declarative sentence can be turned into an interrogative sentence, which means that you can tell the jury, the prospective jury, absolutely anything you want by asking them a question. To get an answer? No. See, to get an answer would be in aid of the first purpose of jury selection, acquiring information about the jurors. Here you ask the question not to get an answer, but to communicate a fact to the jury, because the asking of the question communicates that fact. Hence the importance of always knowing your purpose and then adapting the means to achieving that end. Example, I want to tell them that my name is Irving Younger. I can do it with a declarative sentence. My name is Irving Younger. I'm not supposed to use declarative sentences on voir dire. I'm supposed to ask questions. So turn it into an interrogative sentence. Did you know that my name is Irving Younger? I don't care about the answer. I care about the question, because they now know that my name is Irving Younger. Did you know that I'm going to call a witness, John Q. Bystander, who's going to tell you that he saw this accident? I didn't know that. He's also going to tell you that a couple of years ago he served a term in the state penitentiary for burglary. Did you know that? No, didn't know that. But now they know it, see? And that's the idea. Now, that second purpose will overlap the third purpose, because it's under the heading of the third purpose that we will discuss the circumstances in which you will want to tell the jury about particular facts as early as possible, ideally in the voir dire. Now, in a federal-style jury selection where you can't question the jurors, for all practical purposes, there's no way of seeking to achieve that second purpose, so you'll do it on the opening statement. The third purpose of jury selection is, as I've already said, the most important of the three purposes you seek to achieve when you pick a jury. But beyond that, ladies and gentlemen, it is as close as I can come to stating the secret of being a good litigating lawyer. If you were to run up to me and put a .38 revolver to my head and say, upon pain of instant assassination, Younger, what is it that marks a good litigation lawyer, especially a good jury lawyer, this would be my answer. You will understand then that ideally I should talk about this now in connection with jury selection, and again in connection with the opening statement, again in connection with direct, with cross, with summation. This overrides everything that you do in the courtroom. Given its importance, I will not repeat it over and over again, but I will take 15 or 20 minutes to put it before you as clearly and as effectively as I can. And I like to back up and ask some seemingly unrelated questions and flesh out answers to those questions, but ultimately we will return, I assure you, to this third purpose of jury selection. You know, ladies and gentlemen, I know a few of you slightly. I know most of you not at all. Nevertheless, I do know one thing about each and every one of you. It is something you believe. It is a belief I share. So that's something we all have in common. And the reason I know you believe this is that you are here today. You are not in the office doing your work. You're not at home doing more pleasant things. You're not out on the tennis courts or the golf links on this lovely early spring day. You are sitting in an increasingly stuffy room, listening to some madman scream at you. Why? On the off chance that you will pick up something that may help you to be better. And that brings me to something I know you believe. In litigation work especially, the quality of the lawyer counts. Good lawyers get better results in the courtroom than do lawyers who are not so good. And while it is a secret I would not want to go outside the profession, here in the family we can state it. In other branches of what lawyers do, that is not necessarily so. Some of you have partners or friends, for example, who engage in that kind of work commonly called the green goods business, writing registration statements for the SEC. Assuming the minimum level of competence it takes to get the SEC to accept for filing a registration statement, you realize nothing else counts. It doesn't matter whether it's very good or only moderately good, because in the history of the Western world, no investor has ever read a prospectus. You know that. It's something lawyers do for other lawyers, but the public has absolutely no interest in it. It's just one of the polite fictions we indulge in, that this is what informs the public and prevents them from being defrauded or misled. So the quality of counsel is really rather unimportant in those other branches, assuming minimum competence, of course. Assuming minimum competence in the courtroom, the quality of the lawyer is all important. And here is my sense of the reason why. Lawyers, by and large, are rational people. The clients may not be rational, but lawyers are. When the client comes to a lawyer with a dispute, and the lawyer sees that that dispute admits of only one possible solution, that dispute will not go to trial. There are exceptions, to be sure, but so few as not to be worth worrying about. If there's only one possible resolution to this dispute, there will be a settlement, a guilty plea, a withdrawal of the indictment, some resolution short of a trial. It's very difficult for laymen, for people outside the profession to understand, but it's so. All of you know it as well as I do. If a dispute goes to trial, it's because that dispute is a genuine horse race. There's no predetermined correct result. There's no one truthful answer to this question. Everything depends upon how things work out in the courtroom. Now, to the outsider, a trial is a disinterested search for the truth. That's why this is so hard to understand, and the truth is the truth. It doesn't change. We as lawyers know that the truth has something to do with what goes on in the courtroom, but not everything. What goes on in a courtroom is essentially an exquisitely subtle method of resolving disputes. One hopes in accordance with the truth, but not necessarily. And if you have any doubt about that, not necessarily, think of the exclusionary rule of Mapp against Ohio, or the privilege against self-incrimination, or so many other rules which have as their purpose the achieving of social objectives which are inconsistent with arriving at the truth. And it's because we value those other objectives more highly than we value arriving at the truth. If a case goes to trial, then, it is a horse race, putting aside those few exceptions, which means there's no predetermined correct result, and given such a genuinely triable issue, the following hypotheses are, I do believe, true. If on the one side you've got a good lawyer, and on the other side a bad lawyer, the good lawyer always wins. And I use the word always advisedly. Somebody is bound to be tempted now to ask a question. If that is so, what does it tell us about justice? Because after all, good lawyers tend to be more expensive than bad lawyers. And a poor person can have a horse race as well as a rich person. And a poor person can't afford to hire the kind of lawyer who will be good as opposed to not so good. What about that? And I tell you that that is a very troubling question in the abstract. In the real world of litigation as I know it, it's not a very troubling question because it's rare that you have a good lawyer against a bad lawyer. What you usually have, at least in my neck of the woods, is a genuinely triable controversy, yes, but with a bad lawyer on one side and a bad lawyer on the other side. And you know, the system works. So long as the lawyers are bad, yes, but evenly matched, somehow things come out all right. And the third possibility is the rarest of all. And I mention it because if you ever hear that such a case is going to be tried, my advice is drop what you're doing. Rearrange your professional and your private life. Make it your business to be sitting in that courtroom watching. Because you will learn more than I can ever tell you. And you will be proud of the profession. And you will be astonished. And that is what you will see when you've got a genuinely triable case with a good lawyer on one side and a good lawyer on the other side and a judge who knows how to be a trial judge. I say you'll be astonished. You know why? It's faster than you ever would have thought possible. 1 month trials take 1 week. 1 week trials take 1 day. 1 day trials take 1 hour. It's quieter than you would have thought possible. When you've got good lawyers on both sides, there are very few objections. We'll talk about the reason for that a little bit later. When you've got a good judge, when there is an objection, do you know what you get? I wonder whether it's as rare here as it is in my area. When somebody makes an objection, a good judge rules. Rules, for God's sakes. You don't get a speech, you don't get an apology, you don't get a request for, the judge's request for a sidebar conference with agonizing over whether he should sustain it on the ground that it's a leading question or not. All he does is rule, objection, sustained or overruled, because a good judge knows that to a good trial lawyer, it's the rhythm that's more important than anything else. The ruling is secondary, but let's get it on the beat so that the thing keeps moving along, and sidebar conferences and long agonies over whether you should or you shouldn't, that breaks up the rhythm of the thing. Well, that's rare. Keep an eye out for it, and if you ever hear of such a case being tried, make it your business to be there. But now, let me address something that's implicit in what I've already said. If, as I kind of believe you all agree with me, good lawyers get better results than bad lawyers, they simply win more cases, isn't it important to define what it is that constitutes a good trial lawyer? What are the ingredients that go into the making of a good trial lawyer? What's the recipe for a good trial lawyer? And the fact is, I cannot define it, I cannot list the ingredients, and I can't give you a recipe. And to my knowledge, nobody has ever been able to define it, list the ingredients, or give you a recipe. That's not to say that good trial lawyers aren't recognizable. Indeed, they are. At this moment, somewhere in this city, lawyers are trying cases. If all 400 of us could be rendered instantly invisible and transported to the back of whatever courtroom it is where lawyers are presently trying cases, if by any chance among those lawyers now at work there is a good lawyer, every one of us, without exception, would instantly recognize that lawyer to be a good lawyer. Yeah, we can't list the ingredients, we can't give a recipe, but as Justice Stewart once said in a somewhat different connection, I recognize it when I see it. Right? Jacobellis against Ohio, concurring opinion. He was talking about pornography. We're talking about what it takes to be a good trial lawyer. You recognize it, though you can't define it. I'm not going to give up so easily. I can't define it, but I want to resort to a potentiality of language well known to all poets. You may not be able to say it directly, but by figure of speech or metaphor, you can somehow get the idea across. And because this is central to everything I have to say about trial practice, I'm going to take 5 minutes or so to put that metaphor before you. This is an image which, as effectively as I've been able to manage, conveys what it is that, to my mind, characterizes an able trial lawyer. And in order to present the image, ladies and gentlemen, I must impose upon your good nature for a couple of minutes to sketch out an early chapter of the autobiography I will write in my dotage a few months from now. In that early chapter, I would tell you that I was born and brought up in New York City, in a neighborhood of New York City that might, if you wanted to indulge in overpraise, might be described as a noisome slum. It was an unbelievably bad neighborhood because my parents, lovely and beloved people, very hardworking, not educated, and never got more than $1 or $2 ahead of the game. There was just no money when I was growing up. I mean, we were poor, so we lived in this dreadful neighborhood, and you did your best to pay the rent as best you could. I was the first child, so my parents had to work out the problems of raising a child in a dreadful neighborhood when you didn't have any money to spare with me. Now, from roughly Labor Day to July 1, there was no great difficulty because I went to school. And the way we handled it was this. My mother took me to school, walked to school. You walk the 7 or 8 blocks to school at 8 o'clock in the morning, and she put me in the school building and closed the door behind me. And at 3:30 or 3:45, when the teachers let me out, Mother was waiting for me at the door of the school building. She walked me home to the multiple dwelling where we lived, and she put me in my room in the apartment, and she locked the door, and that was it. I was good till the next morning. So that's how little Irving survived from Labor Day until July 1. But you see, came July 1, no more school. You've got the 8 or 9 weeks of the summer vacation. And what do you do with little Irving, who's 7 or 8, 9 years old? Well, he can run around the streets. He knows enough not to get run over. But to let him run around the streets raises a very substantial risk that he won't make it, either physically or morally, because of the nature of the neighborhood. And remembering it, I fully agree with my parents. You could not leave a kid alone in that neighborhood. So send him to summer camp. Come on, there's no money for summer camp. Put him in a public program of one kind or another. I don't know that there were public programs, and if there were, my parents did not know about them. But they came up with a very ingenious and inexpensive method of babysitting that took care of those summer weeks. Even though I was only 8 or 9, I could get around the transit system, and the transit system was pretty safe. New York City in those days had trolley cars, electric railways that ran on the street. We happened to live right on the corner of a trolley car stop, and the fare was a nickel. And every morning at 9 o'clock, my mother put me on the old trolley car, and a nickel in the box took care of it. And I sat on that trolley car for 12 minutes, and then I got off at the Yankee Stadium on the other side of the Harlem River. And there was the Yankee Stadium that's there today, except it's since been cleaned up. But it was pretty good in those days, and they opened the doors to the bleachers at 9:30. And the price of admission was a quarter. So for a quarter, I got inside. And once you were inside, it was perfectly safe. There was no hooliganism, and there were a lot of uniformed attendants around. You just sat there, waiting for the game to begin. Along about 11:30, you got hungry. You needed lunch. A dime. Bought a hot dog. That was lunch. And then at 12:30, the game started. And you watched the game until 4 or 4:30. Then you came outside, got on the trolley car, put a nickel in the box, sat on the trolley car for 12 minutes. Mother was waiting at the trolley car stop, took me off the trolley car, put me in the apartment, locked the door, and little Irving was good till the next morning. So for 45 cents a day, there was perfect babysitting. The consequence for me, ladies and gentlemen, was that I spent most of the long afternoons of my childhood and early adolescence watching the Yankees play ball. Now, I'm not as old as I look. I never saw Babe Ruth, no. Many of you are baseball buffs. Some of you may even come from New York. I was watching the Yankees of the years before World War II. And of course, it's part of my consciousness. I can run around the infield. I guess some of you can too. Remember? Bill Dickey, Buddy Hassett, Joe Gordon, Frankie Crosetti, but then Phil Rizzuto, Red Ralph, Charlie Keller, Joe DiMaggio, Tommy Henrich, and that great pitching staff of Red Ruffing, Lefty Gomez, Fireman Johnny Murphy. Oh, great men, every one of them. Well, I made it. As you see, I survived both physically and more or less morally, and in due course I went off to college, and came the last day of college, and I put the period to the last line on the last paragraph of the last page of the last blue book I ever was going to write. As I got finished in the June of my senior year, the one thing I thought I knew was that I had had enough of school. I was never again going to see the inside of a classroom. The lesson being, don't be too sure you know your own future. Had you told me at the end of my senior year in college that I would end up years later going back to school, becoming a lawyer, and ultimately becoming a law professor, I would have vomited in my shoes. That's what I would have done. No, ladies and gentlemen, I determined that I was going to be a newspaper man. I was going to be a journalist, yes, sir. And if I'd known what I was doing, I would have gone to a smaller city, which is where you begin, and then you work back to the New York Times, the Washington Post, or something of that kind. I didn't want to do that, essentially for reasons of girlfriend. I wanted to be in New York. So, upon graduation, I came to New York, and I went around to the papers and said, please hire me. And one of the New York papers hired me as a copy boy, which is how everybody starts. It was a paper called, no longer exists, the New York Daily Mirror. It was the Hearst Empire's attempt to compete with the Daily News, you know, tabloid against tabloid, and ultimately it just lost too much money, so they folded it. The Mirror was the worst newspaper ever published in the history of America, no doubt about it, and that's probably why they gave me a job. And I worked faithfully for a couple of months as a copy boy, and then lo and behold, there was an unexpected opening on the reportorial staff, and I got it. And I wasn't even 21 years old, and I was a reporter on a New York City newspaper. And you know in which division? The sports division. So I was a sports reporter for the New York Mirror, covering baseball. And the team I covered was the Giants, the New York Giants. And I cannot convey to you the excitement of just going to work every day. You know what I did when I went to work? I went to the Polo Grounds. I sat in the press box above the first base dugout with the photographer from the Mirror. The pictures were more important than anything else in the Mirror, and this was my job. The photographer took pictures, and I made notes of what he was taking pictures of. Then, since he was senior, at the end of the game, he went home. I took the plates back to the city room. I waited around while the plates were developed. The picture editor then selected those pictures that were going to be printed in the next morning's newspaper. When he made his selection, my job was to be a reporter. I typed out the thin line of text that went underneath the photographs. Because, you see, the mirror was put out for people who were lip readers, so you couldn't make too many demands upon them. The coverage of the game was the box score, the pictures, plus my little line of text. This is a picture of the catcher throwing out the runner at second base, period. That was about it. And my day's work was done. But I couldn't go home. I was too excited. I was too elated and keyed up. The thought at the age of 20 of actually covering the New York Giants for a New York City newspaper. So what I would do instead of going home is sit in that corner of the city room devoted to the sports section, and there were my older colleagues, guys who indeed had seen Babe Ruth play. Some of them had seen Cy Young pitch his first game. That's how old they were. And I would spill over because of the youthful enthusiasm that filled me. And, you know, I had just come back from the Polo Grounds and seeing the Giants in the early 50s. What would I say to them? But, you know what I saw today, gang? And they say, no, Irv, what'd you see? I saw Willie Mays make the most incredible catch I have ever seen. The batter hit the ball on a line out to center field. With the crack of the bat, Willie turned his back to home plate and ran 70 miles an hour right out into center field. He's 20 feet in front of the fence. He looks up over his left shoulder. The ball is coming down. He's going too fast to stop. There's no time to turn around. So what did Willie do? He turned himself into a human donut, and he rolled to the fence. And as he rolled, he got his glove up between his legs, and he caught the ball, the most incredible thing I've ever seen. That guy has to be the best center fielder who ever lived. And my older colleagues would say, no, Irving. Willie's good, there's no doubt about that, but he's not the best who ever lived. And I would say, what do you mean he's not the best who ever lived? Then if Willie isn't, who is? And these older colleagues of mine would say, well, Irv, all things considered, the best center fielder who ever lived was probably Joe DiMaggio. And I would say, you're out of your mind. I spent most of the summer afternoons of my childhood and early adolescence watching DiMaggio play ball. I must have seen him play 300 games, and not once, not bloody once, did Joe DiMaggio ever make the kind of incredible catch that Willie Mays makes 3 times a day. How can you say he's the best who ever lived? And their response was, that's right, Irv. That's right. Joe DiMaggio never once made an incredible catch. You see, when DiMaggio played center field and the batter hit the ball anywhere in the outfield, as the ball reached the peak of its trajectory and turned to begin its descent to the ground, there, idly standing beneath the ball, tapping his glove, breathing quite normally, was Joe DiMaggio. He put out his glove. The ball infallibly landed in the glove, and with an almost insolent grace, he returned the ball to the infield, hence permitting the game to resume. That, said my older and wiser colleagues, was the best center fielder who ever lived. And the more I've thought about it, the more I've concluded that they were right. That was, at his prime, the best center fielder who ever lived. And what's more, that image of DiMaggio playing center field, as he played it in 38, 39, and 40, represents the most vivid picture I can put before you to convey what it is that marks an able trial lawyer. Now, let there be no misunderstandings. You don't have to be a man, and you don't have to be Italian, and you don't have to have that wonderful saturnine handsomeness of Joe DiMaggio. I see some of you looking at me in puzzlement. I forget how young some of you are. The man on television selling coffee machines. Yes, that's the man I'm talking about. There are an infinite number of ways of achieving what I will call the Joe DiMaggio effect, because there are an infinite number of combinations of human factors. So you can do it in whatever way makes sense for you. But every able trial lawyer I have ever seen does it unthinkingly. Obviously, people don't articulate it as I've just tried to articulate it. Every transcript of every trial I've ever studied involving an able lawyer, the Clarence Darrows and the Earl Rogers and the Sir Edward Carsons, indicates that this is the basis of it. This is the magic that characterizes an able trial lawyer. I should not attempt to translate it into words, because that's the nature of a figure of speech. It does it without translating it into words. But simply in In an attempt to be helpful to you, let me try, however lamely, to translate it into words. When DiMaggio played center field at his prime, when the ball was hit out to the outfield, what did you know? You knew he was going to catch it. It was not very exciting to be sure, but still a kind of surface excitement of Willie, where the question was, maybe he wasn't going to be able to do it. With DiMaggio, it was the sublime confidence of course, he's going to catch the ball. Put it this way, I wish I had a time machine to go back to 1939. Red Ruffing is pitching. He throws the ball in, the batter hits it, it's on the fly out to center field. Everybody turns to watch DiMaggio. I would have watched Ruffing, and you know what? I bet Ruffing never turned around. He never looked out to the outfield. He knew the ball was going to be caught. He began to think about the next batter. In one word, reliability, trustworthiness. The reliability of course he's going to catch it. The trustworthiness of the ultimate professional. That's God's idea of how to play center field. Every good trial lawyer, well, let's focus it as we said we would focus it. Every good jury lawyer that I've ever seen myself or been able to study on the page of the transcript somehow gets across to the jury the idea that he or she is reliable. Now, there are many, many facets to that. It means technical proficiency, professionalism, knowing your job, and most importantly, you can't fool them. Tell them the truth. That's how to be reliable, that's how to be trustworthy, and to the extent that I can pretend to know anything about how juries react to cases, given a genuinely triable controversy, a horse race, there's no predetermined correct result. The jury chooses up between the lawyers. Now, it may be happening subliminally, beneath the level of consciousness, but it happens. And the lawyer that strikes them as more trustworthy is the lawyer who wins. And that's why good lawyers win more cases than bad lawyers. And the good lawyer is the lawyer who manages to get across to the jury his or her trustworthiness. Now, I could go on all day about that, but let's put it in the context of jury selection. I'm going to assume a state-style voir dire, where you talk to the jurors. If you pick juries in the federal court, you can't talk to the juries in connection with jury selection, but you can talk to them in the opening statement. So everything I say would be applicable to the opening statement. Let me take just 3 aspects of the Joe DiMaggio effect. First, it's subtle, but I think we all understand it. Many of us have seen DiMaggio play on newsreels, videotapes, if not in the flesh. And he had a wonderfully clean line. A ballet dancer would have admired DiMaggio. It was the truly perfect athlete. And you know what I mean? Standing up straight, elbows in. He had to put his glove out, yes, so that the ball would land in it. But apart from that, nothing was extra. It was just a pleasure to look at the elegance of his body doing a very difficult thing, catching a high fly ball. The analog for the lawyer in court of the elegant line of the athlete or the dancer is lucidity. It's an intellectual elegance of line. And by lucidity, I mean, of course, that the jury must hear you, but I go beyond that. They must understand you. And that's worth talking about, because remember, they are not the judges of your state Supreme Court or of the United States Court of Appeals. They are lay people with limited educations. Necessarily limited. They're not lawyers. Right? They may be PhDs in something else, but with respect to the law, they are all novices. And by the way, I'm probably going to say it again, but let me say it now. That is the only respect in which we have the advantage over them. Collectively, the jury is quite as smart as we are. Indeed, they're usually smarter than we are. But they lack technical sophistication. That's the only thing we have on them. Now, they must understand you, because they are your audience. They are going to decide your case. Which means what? Which means, at a minimum, you must, if you're going to try jury cases, reacquire the knack of speaking plain English. I address especially the younger lawyers in the room. The older hands have long since reacquired that knack. I say reacquired because we all once had it. But then we go to law school, and we spend 3 years practicing distorting the English language. That, after all, is what law school is. You know that. When you reach that wonderful moment when the law professor pats you on the back and says, terrific, you're talking like a lawyer, that means what? You no longer speak plain English, right? There's a kind of vaster dialect of the language spoken only by lawyers. You know that. Only lawyers say prior to when they mean before. Only lawyers say subsequent when they mean after. Only lawyers say motor vehicle when they mean car. If you have learned how to speak like a lawyer, but you want to be a trial lawyer, you now have to backtrack and reacquire the habit of speaking plain English. There are two important reasons for doing so. Reason number one, I'll mention now. The jury has to understand you. And you know, as the beneficiaries of 7 years of higher education, we think that the word subsequent is known to everybody. It's not. And prior, and motor vehicle. But you take 12 people in off the street and ask them, what does the word vehicle mean? And 3 of them aren't going to be quite sure. Maybe one of them ends up on your jury. So you say to some witness, what did you then do with respect to the operation and control of your motor vehicle? Which is how a lot of lawyers like to ask it. And the juror starts to say to himself, what? What the hell is a vehicle? What is a vehicle? You know. And maybe he decides, or he guesses on the basis of what it sounds like. You know what it sounds like? He says to himself, it sounds like a sidecar on a motorcycle. What motorcycle? Where'd the motorcycle come from? And he's so worried about figuring out what it is you're discussing that he's not listening. And if he's not listening, you're not going to be able to teach him, and you're not going to be able to persuade him. So simply for reasons of comprehensibility, you must speak plain English. There is another reason as important, but I like to discuss it in connection with the opening statement, so save it for a while. I'll remind you when we come to it.